All right. Hey there, everyone. So this is Chris Fair with Castle Wealth Group. We do these weekly wisdom webinars about every Wednesday, and it's just opportunity to answer any questions people have. You can submit questions ahead of time, or if you want to put into the Q&A any questions, legal, financial, tax planning questions you might have. I always like to start with a positive focus, just something positive that's happened over the last week or so. My daughter soccer season just started, so I was able to coach my daughter in soccer this weekend. Fortunately, we didn't get the win, but it was a close game, fun game, and she did pretty good. So happy with that. All right, we'll get into the questions. So give me a second. And again, if you do have a question, feel free to put it in the Q&A. So here's one question. I talked about this, but want to go over it again. So we plan on leaving money to our grandkids who are age 21 and 26. A big portion of the estate upon death. We set up separate share trust for each one of them. My question, is there a way the grandchildren trust can be in their social security numbers, and can it be a grantor trust? Okay. So here's a situation as I understand it. So we set up a trust and we built in what we call legacy provisions. So understand when you leave something to a beneficiary, you can leave it outright to them. But the concern is if there's a divorce, a lawsuit, creditor action, bankruptcy, um, then that money could be lost. Or if they pass away, that money might go to a spouse who might remarry versus going down to your grandkids or to your other children. And when we set up that basic revocable living trust, it's what's called a grantor trust, and it's still in your Social Security number. But when you pass away, the trust becomes a non-grantor trust. And at this point, we need to get a separate tax ID number for those separate share trusts. Now, the concern, I guess, I'm guessing kind of where the real question comes into play is now, are those separate share trusts taxed at trust tax rates? And the answer is no. They're still taxed at personal income tax rates because the income goes out to the beneficiary. So even though, yes, we are getting separate tax ID numbers for those separate share trusts to protect the beneficiaries from divorces, creditors, bankruptcies, et cetera, it's still, you do have to have that separate tax ID number, but it's still taxed at personal income tax rates. Um, it's a common question because a lot of times people see the term trust, and if they look at like tax rates, they assume it's falling under trust tax rates. Understand in our office, 99 times out of 100, we're not falling into the trust tax rates. There has to be a very specific reason why. So in that situation with leaving money to the grandkids, yes, they do have to get a separate tax ID number for the separate share trust, but it's taxed at personal income tax levels. So it's really not an issue at all, other than just getting a separate tax ID number. Another question. My trust was made in 2013 and is still correct. Is there a time limit on trusts? Yeah. So the question is, created a trust in 2013. Is it still valid? Trusts remain valid, but I would say with an estate plan, there's two things that can come up. Well, three things. One is there could be changes in your family situation. Like maybe you set up the trust and now the kids were younger and you didn't have them serving. Now maybe you want the kids to serve. Second, there could be changes in law. Uh, for example, 2020, we had the Secure Act. 2018, we had the Tax Cuts and Jobs Act. 2012, Michigan changed the financial powers of attorney laws. So the laws are always changing. Even this year, we had the bill that got passed July 4th, the one big, beautiful bill. So laws are always changing, which sometimes would warrant a change to an estate plan, depending on how it's set up. And then third thing, especially if you have a trust, is you need to make sure the trust is still funded correctly, making sure all the different accounts and assets are still pointing to the trust. Like you might have done the trust in 2013, we would have helped you like get everything funded and titled correctly. But if we haven't talked and it's like 10 years plus down the line and you opened up a new CD, we need to make sure that that account is pointing to the trust. It's not like the trust has to specifically list those accounts. It's just that those accounts have to point to the trust. So yeah, the trust is still valid, whether it warrants a update, it would depend on your family situation, any changes in law, and then just making sure the trust is funded correctly. All right, let me see what else we have. Oh, here's another one. Uh, are death benefit insurance subject to taxes? So I think what the question is okay, we have a life insurance policy, person passes away, someone inherits it. Is there any tax due on that? Most likely not, because we have what's called the estate tax, so or the inheritance tax or the death tax. So when you pass away, as long as you're below the exemption amount, there's zero tax due to the beneficiaries. With the one big beautiful bill that got passed, that estate tax exemption is set at for next year, $15 million for a single individual, $30 million for a married couple. So as long as you pass away or whoever's passed away is leaving less than that amount, there's zero tax due on any life insurance, real estate, investments. The only tax that might have to be paid would be if you're inheriting any type of pre-tax money, like from an IRA or 401k or 403b, money that was never taxed. Um, and with the Secure Act, which passed in 2019, became effective 2020. Prior to the Secure Act, you were able to stretch out those beneficiary IRAs over like your lifetime, paying like maybe a 3% tax each year. But now all the taxes have to be paid within 10 years. So, long story short, life insurance, as long as you're below the state tax exemption, is tax free. Basically, everything else is tax free. You get a step up in basis. The only thing your beneficiaries would have to pay tax on would be your pre-tax accounts. Here's another question that just came in. When to use a ladybird deed? When should you use a ladybird deed? So a ladybird deed is a type of deed that says the home is in your name while you're alive and well, and then upon death, you can have a beneficiary on it. You can have a trust, or you could have like individuals listed as a beneficiary. So it's like beneficiary designation for real estate. So when would you use a ladybird deed? Almost always. Really, the only time you wouldn't want to use a ladybird deed is if you're setting up an asset protection trust and you're deeding the property directly to the trust. There's really no downside to the ladybird deed. It's a form of quitclaim deed. It's named after Lady Bird Johnson, and all it is, excuse me, like a beneficiary designation for real estate. So you can still sell the property, you can refinance it, you can mortgage it. But if you were to pass away and the property's still in your name, it avoids probate and goes to whoever, or whatever was listed as a beneficiary, thereby avoiding probate. If I can't find the deed on my home, is there a place I can get it? How? And how much? But yeah, so you don't need to have an official copy of your deed because it's recorded at the county. So if you lost it, and whenever we're doing a new deed for clients for their estate planning, we always pull it from the county. So you can go directly into the county. A lot of times you can go online and download it. It's public knowledge. So just whatever county you're in, kind of Google the Register of Deeds and reach out to them to get a copy of that deed. It's public knowledge. All right. Okay. That looks like all the questions I have for this week. So if you do have questions, feel free to email them over. And again, we'll be back next Wednesday at 1 o'clock. Make it a great week. Take care. Bye-bye. 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 Bye-bye.